Welcome to Podcast 83, a regular look at the news, stories, and trends related to Michigan's 83 counties from the Michigan Association of Counties.
All right, good afternoon, everyone. Welcome to Podcast 83, the podcast put on by the Michigan Association of Counties. My name is Steve Currie, the Executive Director of MAC. Today we have Deena Bosworth, Director of Governmental Affairs for MAC, and Ted Seitz, who is an attorney with Dykema, who has been working in depth on the foreclosure issue back for many years with Raffaele, and now there's some federal cases we want to update folks on. Ted's been really generous with his time in our committees and updating our committees, and we thought it'd be great to bring it to a greater audience with our podcast. So welcome, Ted. Thanks.
Thank you. Thanks for having me.
So Ted, why don't you kind of take us back a little bit, brief update, Raffaele legislation. Now we've got some federal issues that could impact property tax foreclosures.
Right. Well, some of us may recall in 2020, July 2020, the Supreme Court issued a decision in the Raffaele versus Oakland County case. And that decision dealt with Michigan's tax foreclosure laws, which had been in place since around 2000. And specifically, the Raffaele court held that the retention of what it labeled as surplus proceeds, so that amount that is there between the taxes and the amount that the property may be sold for, violated Michigan's Constitution. It did not violate the federal Constitution. There's something called the Takings Clause in the U.S. Constitution that I'll talk about in a few minutes, I'm sure. And so at that point, after this decision came down on the surplus proceeds piece, and there had been a variety of class action lawsuits that have been filed by the various counties that were pending at that time in state and federal court. And there had been some federal lawsuits even before then, one called the Wayside Church case versus Van Buren County that had been pending for a while. But after Raffaele came down, and this is in the middle of COVID, the association, MAC, and the Treasurer Association and others got together and drafted legislation to deal with the Raffaele case and this surplus proceeds holding. And working through this kind of COVID time, they drafted legislation. It went through, obviously, the committees and then went to the legislature, where these acts, which ended up being Public Act 255 and 256, were passed unanimously by the Michigan legislature and signed into law by Governor Whitmer on December 27th, 2000. And what the new law did is it amended the General Property Tax Act, so the act that was at issue in Raffaele, to create a process for people to retain their surplus proceeds. So that's where we sat.
So Ted, that's basically, okay, we can take out, some of our expenses for the foreclosure process, and then whatever is left, then, people can apply and have that, retain that money. So
Yes.
We no longer get to keep the surplus from those sales if they apply for, that reimbursement.
Yeah,
If
that's
they
absolutely
don't
right.
apply for it, what do we do with it?
If they don't apply for it, and again, even if they apply for it, they file a notice form, the circuit court has to approve, the surplus proceeds if there are any. But if people do not apply for those surplus proceeds, then they remain with the county treasurer in the delinquent tax revolving fund. So.
And we've had that delinquent tax revolving fund, prior to Raffaele in 2020, that delinquent tax revolving fund has been something the counties have been able to utilize those surplus funds for different things within each county based on their discretion, correct?
Yes, absolutely.
Use it for additional, foreclosures and to help support Treasury Department. Sometimes it went to the county general fund. They were just deposits because it was kind of like us recouping and going through the effort of trying to recover taxes.
Right.
Okay, just
Yeah.
clarification. But
Yeah.
now, people can apply for it. They can keep those extra dollars, and we are, just got to kind of sit on it and wait for them to claim it.
That's right. That's right. And there is one other piece there. So, the properties could be also taken under the right of first refusal. So in addition to properties being sold at foreclosed, there is the option, it remains for the state, the local governments, the counties to take the properties under the right of first refusal. And that situation also is built into the new law, right? So you have to pay the fair market value of that property above the tax amount, right? If it's taken a right of first refusal. So that's one little caveat that's sitting out there.
Great. Because we're not dealing with, redeeming property. If people decide that they're going to pay their taxes prior to the end of that foreclosure situation and try and redeem their property, that's one thing. We're talking about when they have not tried to redeem their property, we go through the whole foreclosure process, then end up taking possession, then what happens to it?
Yeah.
We either first right of first refusal for the locals to take it or put it on the market and get rid of it.
Right. That's absolutely right. The circuit court still controls the foreclosure of the property. People still have the right to redeem it. We're talking about those parcels that are unredeemed, and then transfer to the treasurer.
Great. Okay, so that was Raffaelli. So we've dealt with the surplus part of it. And now enacting the legislation, we all know where we're going moving forward. Now what's going on?
Right. So while all of this is going on and has been going on, there have still been cases up in the state and federal courts, mostly dealing with these class actions that have been filed, and there's some individual actions. One of series of cases is out there dealing whether Raffaelli, the decision was retroactive or prospective, which is also mentioned in the new law that was passed, that it's deemed to be prospective unless the Supreme Court, the Michigan Supreme Court, holds that it is retroactive. So there are several cases now up in the Michigan Supreme Court asking them to decide this issue. And they're called the Schaefer case against Kent County, and the Proctor case, which is against all of the counties basically in Michigan, except for Wayne and Oakland. And there's a flurry of other cases. So that is one piece. In the federal court, there have been a series of class actions that remain pending in front of the different courts in Michigan and the United States Sixth Circuit Court of Appeals. And one such case, an opinion came down late last fall in a case titled Hall versus Meisner in Oakland County. And in that decision issued by the Sixth Circuit Court of Appeals, there's actually two, but the more important one for now, the published opinion, stated that Michigan's tax foreclosure law, when people's property were foreclosed, at the next day for those properties aren't redeemed, constitutes a taking under the Fifth Amendment of the United States Constitution. And this was the first time that a federal court had held this. And there are other states that are dealing with the same thing that Michigan is. So states like Minnesota and Nebraska, and there's other states that have the same system that Michigan used to have. Texas is one, Alabama, and different circuit courts in the United States. And this is one level below the US Supreme Court, have held differently on this issue. So there's a case I'm going to talk about in a few minutes, I'm sure, called Hennepin County, which is Minnesota's tax foreclosure law. And the United States Eighth Circuit Court of Appeal held that that law did not violate the takings clause. That law is very similar to what Michigan law looked like before the legislation was passed in December 2020, changing it. So that was the Hall-Meisner case was a sea change at the federal level on how the tax foreclosures in Michigan were viewed. It's a federal takings, meaning in the Constitution of the United States, the Fifth Amendment, there is Article 5, or excuse me, the Fifth Amendment says that the government cannot take property without just compensation. And that is the piece that the Sixth Circuit said. Michigan's law, when properties are foreclosed upon, and especially when they're taken under the right of first refusal, that is a takings violation. So
But
that
you have
case-
another court
yeah.
that said it was okay. So you have
Yep.
conflicting rulings, right? At the
Yep.
same.
Yep, yep,
Okay.
we're not alone. So in Michigan, there's conflicting rulings. The Eighth Circuit says one thing on this. The Sixth Circuit now says one thing, and actually there's a case in the Seventh Circuit that is yet to be decided, dealing with Wisconsin's law. And who knows how's that gonna come out. So that's the state of the law in the United States at the federal court level. The Oakland County case, Hall, that case still is subject to a possible, what we call a cert petition. So that means you ask the United States Supreme Court to take a look at this case. They don't grant many. They grant very, very few. But the Oakland County, the Hall case, that could still be subject to a cert petition, asking the justices, hey, this is an issue that we should look at. However, in the meantime, the United States Supreme Court recently granted cert, so granted permission almost to appeal a case from the Eighth Circuit. So the case we just talked about, the Hennepin County case. The Supreme Court, I think it's about a week ago, issued an order saying that we wanted to take up this case. And it is a Fifth Amendment takings case. It deals again with Minnesota's tax foreclosure law. And they want to decide the issue. So that case now becomes at the 10,000 foot level, the most important case on this issue, because the Supreme Court will now issue an opinion by June of this year, because that's the way the Supreme Court has to issue all its decisions by June of this year for cases that are argued before the June. So this Hennepin County case will be argued in late April of this year. The briefs will be submitted to the court in the coming months. And there will surely be others who are going to want to weigh in on this issue. And by that, I'm meaning amicus briefs. So amicus is called friend of the court, it's Latin. And so there will be others from around the United States that want to let the Supreme Court know that this is an issue that's wider than even the Hennepin County case. So that is kind of the 10,000 foot view of where we sit. We have now cases in the United States Supreme Court, the Sixth Circuit Court of Appeals, the federal district courts in Michigan, other places, and then the Michigan Supreme Court, all still wrestling with the Michigan tax foreclosure law and what it means. No case yet dealing with Michigan's amendments to that law. So we're talking, they're looking at, kind of what Michigan law looked like before. But still it is, once the Supreme Court decides this issue, that will then become the law of the land for all states.
And
So
just,
for us, oh, sorry. Go ahead,
so
Steve.
just to clarify, when you say the Supreme Court, you're talking US Supreme Court.
Yes, that's right. That's right.
We still have cases, we have retroactivity still at the state Supreme Court.
That's
correct?
absolutely right. That's absolutely right. Yep. We have so many courts dealing with these issues. So yes, that's what the Supreme Court has, the federal takings piece. The Michigan Supreme Court still has retroactivity, prospectivity, which relates to Michigan's new law as well. So now the Michigan Supreme Court just has applications to appeal to them in front of them on that issue. They haven't taken that issue up yet. And there's no guarantee that they will or even when they will do it. So they could have these applications up in front of them currently. They could deny all of them and say, we don't want to touch that issue for a while. We'll see.
Well, now it has a couple of implications on that. So if the Michigan Supreme Court decides retroactivity applies, we don't know how far back, right?
That's
I mean,
right.
would they have to establish that, how far back?
Yes, that's right.
That retroactivity would apply, so we're talking a significant amount of money that counties may have to come up with in order to comply if that's the ruling.
That's right.
And now, would it be in their interest, in the Michigan Supreme Court interest, to wait until the US Supreme Court makes a ruling on this Hennepin case? As far as takings goes, are they related or not related?
It-
How would those interplay if the US Supreme Court decided on the takings issue first?
Yeah, it's hard to tell, right? And so that's the quick answer, right? But I think the answer is something like this, which is the Michigan Supreme Court before, when Adele Raffaelli said Michigan's law doesn't violate the federal takings clause. So they said, we're not going to touch that issue. If the US Supreme Court, and it depends, obviously what the opinion says, that Minnesota's law violates the federal takings provision, it may not ultimately impact Michigan in some sense going forward, especially because of our change in the law, where we do, allow people to obtain surplus proceeds or those with interest in the property. And we do have a mechanism for fair market value for properties taken under right of first refusal. So Minnesota's law is what Michigan looked like before the change in the law. So it will have an impact on pending cases, potentially, especially the class action ones that I'm talking about before that are as to Michigan's old law, but it may not have the impact as to Michigan's current state of law.
Okay. And then one other question, and I know we've talked in the past, but I don't remember this. So our right of first refusal, was the Minnesota law similar in that same right of first refusal for local units of government? Why is that such an issue?
Yes, they can do the same. It might be a little bit different. And Minnesota's constitution is different than Michigan's constitution. There's some material differences, but yeah, I think it's a little bit different. But it does have that piece in it.
Okay. So if the U.S. Supreme Court does or when they decide on this Minnesota case, that's the law of the land. So whatever's going on with Hall Meisner in the Sixth Circuit is kind of a moot point, correct?
Yeah. I think that's absolutely right. That the Hennepin County case will drive what the ultimate resolution is. Now, I think that that issue will still be in front of the Supreme Court on a cert petition, meaning that it'll be there, but the case will be decided in Hennepin County before they ever deal with that cert petition from Hall.
So do we anticipate that a lot of those cases there'll be no changes in those cases, the status of those cases until that US Supreme Court case is decided?
Yeah, I think that's right. I mean, I think that a lot of courts will take a wait and see approach. They don't have to, so they could charge ahead in some of these cases, even knowing that's out there. But I think many of the circuit courts of appeals, they'll probably take a wait and see approach. I mean, the other issue that's percolating in the Supreme Court case and is percolating in the cases that the Michigan counties have faced as well is this issue of states' rights and federalism and who gets to decide, how property tax issues are dealt with. Is that a state law issue? Can the federal government come in and say, no, this is our issue? So that's percolating in here in all these cases, allowing the states to construct their property tax system in a way that they feel is appropriate, because it really is the state's property interests in these properties.
Well, I agree with that. Not that matters,
Right.
but I do agree with that. But I think but the question is it a takings issue based on the US Constitution? So how can they would have to rule and say, no, it's a state issue. It's not a takings. Would they have to do that first?
Yeah, what they would probably say, listen, this on the takings score. This does not violate the takings clause of the US Constitution, because there's still the power of the state to tax, and it has the right to foreclose on property, and so you're really not taking it without just compensation. I mean, they could wrestle with it in that fashion. But there's some old Supreme Court precedent, by old, I mean, 50, 60 years, maybe a little more recent, that a case called New York, Nelson versus New York. It dealt with New York's tax property system. And it said that it was not a federal taking for their system because there was a path for people to obtain surplus proceeds. So that is sitting out there as well.
Okay.
And we wrestle with that.
So as much angst as Raffaele gave us,
Mhm.
it might actually provide a little cushion for us in the future,
Yes, that's
depending on how
right.
yeah, okay.
Yeah, it made us adjust our law, right?
Yep.
And in a popular way, obviously, legislature, because there was not one single no vote as to our amendments to the statute in PA 255 and 256.
Okay. That's good. That's good. Still, I will say this from our perspective, very much concerned about that retroactivity on the surplus proceeds because those funds have been gone for, a number of years. And heaven only knows how far back that may have to go. So I guess in a word of caution to counties out there that do still have surplus proceeds in an account, maybe just kind of hang tight for a little bit just in case of a retroactivity decision.
Yeah, that's right. They should be reserving
Mhm.
funds, certainly. And you're right, that money is gone for years back, which is something that, if the Supreme Court, when and if it takes that issue, we're going to want to make sure that our voices are heard on that piece so that they understand that this has a real ripple effect on public finance issues.
Awesome.
Well, Ted, thank you. Appreciate your time today. I mean, very, very interesting topic, obviously, very in-depth topic. I mean, I remember when Raffaele was first going through, we had this whole litany of cases. At least now we're starting to narrow them down a little bit, get a little more clarity on things as we get closer to, obviously, June, a decision date. So we appreciate your time today. Ted Seitz from Dykema Law Firm. Deena, thank you. If you have any questions on this issue, you can email Deena at bosworth@micounties.org. Be happy to try to talk you through any questions. So thank you, everyone. Thanks, Ted. Thanks, Deena. We look forward to talking to everyone soon. Take care.
You.
Thank you for listening to today's episode of Podcast 83.